All right, we will now take up the right to profit sharing benefits. Have you come across any law that provides for profit sharing benefits? Take note that in the absence of a law that provides for profit sharing benefits, take note that this profit sharing benefit cannot be demanded as a matter of right by the workers or by the employees. In other words, people, this provision of the Constitution on profit sharing is not a self-executory provision. It needs a law to be enacted by Congress to provide these benefits. Now, however, there are companies that provide for profit-sharing benefits, perhaps by virtue of a collective bargaining agreement or company policy or company practice. In other words, profit-sharing benefits in the absence of a law can be granted by way of a collective bargaining agreement, company policy, or company practice. Take note of these people, very important. Now, so another area on labor, we will now take up some pertinent areas on the civil code. Nagbigay sa bar last year dito, so listen. Well, under Article 7, Article 1701, 1702, 1703, etc. on civil code. The civil code provides that the relationship between labor and capital is impressed with public interest, and neither capital nor labor shall act oppressively against the other. I have discussed this in my previous lectures. Another civil code provision. We have this principle of construction in favor of labor. All labor laws and labor contracts, in case of doubt, shall be resolved for the safety and decent living of the laborer. Under the civil code, there are two, shall we say, requirements before construction can be made. And what are these two requirements? Safety and decent living of the laborer. Now, question. The safety and decent living of the laborer cannot be found under Article 4 of the Labor Code of the Philippines. In other words, the Labor Code in the construction of labor, in case of doubt, the Labor Code does not provide this criteria, safety and decent living of the laborer. Does it mean to say that the Labor Code, Article 4 of the Labor Code of the Philippines, should be amended in order to inject these principles or requirements to win safety and decent living of the laborer? The Supreme Court said no more. The Supreme Court said that the rules of court and civil code provisions apply to labor law in their suppletory character, so there is no more need for these principles to be injected in Article 4 of the Labor Code of the Philippines. Okay, this principle of construction in favor of labor, take note that you can be a lawyer because of this principle. If you know this principle of liberal construction in favor of labor. In the event that there are two conflicting laws, two conflicting policies, two conflicting implementing rule or regulation, two conflicting circulars, take note, the one that provides benefits to the worker should be applied, and this should be in accord with what? This principle of construction in favor of labor. Anything that is favorable to labor must be applied. Why? In accord with this above principle of liberal construction in favor of labor. I'll give you one case here where the Supreme Court applied this. It is a worker who died of what we call hemorrhagic pancreatitis or bangungot. O para hindi nyo makalimutan, sabihin nyo hemorrhagic pancreatitis, wala namang problema yun. No? Hemorrhagic pancreatitis is a medical term. Now, so what is this about? So when the worker died, take note that for an occupational disease to be compensable, it should be listed as an occupational disease under the labor code. But the claim of the claimants in this particular case was rejected on the ground that this bangungot or hemorrhagic pancreatitis is not included as an occupational disease. This case reached the Supreme Court. What was the verdict of the Supreme Court? The Supreme Court said that bangungot or hemorrhagic pancreatitis, though not listed as an occupational disease, is compensable. The Supreme Court further said that it does not mean that if a disease is not listed as an occupational disease, that it is not compensable, because the liberality of the law still subsists that in case of doubt, it shall be resolved in favor of labor. The Supreme Court further elucidated that bangungot, which is a prevailing disease in Asian countries like the Philippines, this bangungot, the origin, shall I say, or etiology of this disease is still unknown up to now. Even medical practitioners, medical fraternities on this matter cannot say with certainty the origin of this disease. So the Supreme Court said, since the origin of this disease can be determined with certainty, then it creates doubt, and the doubt must be resolved in favor of labor. So take note of this principle of liberal construction in favor of labor, because, take note again, this principle will make you a lawyer. Okay, another. We have these laborers' wages are not subject to execution or garnishment. This area was given the bar already when the the bar examiner gave this question by requiring the bar candidates to distinguish salary from wage. In the meantime, under Article 1708 of the Civil Code, it provides that laborers' wages are not subject to execution or garnishment. By the way, the Civil Code provides wages, not salaries. So, there is a distinction between salary and wage. This was, the Supreme Court had the occasion to define this, or to distinguish this salary from wage. According to the Supreme Court, wage is paid to laborers, or it is paid to those who do manual labor. These are workers on the lower bracket. On the upper bracket are actually employees who are paid salaries. In other words, since the Civil Code provides that laborers are not subject to execution or garnishment, therefore, salaries of employees are subject to execution or garnishment. It was already declared by the Supreme Court in GAA versus Court of Appeals. You still remember this GAA versus Court of Appeals. So take note of this: wages and salaries. Of course, in another case, the Supreme Court said that when you talk about wages, remuneration, salaries, compensation, and other forms of remuneration, they mean the same thing. Only that, for purposes of garnishment or execution, there is a distinction between salary and wage. So take note of this. Salary subject to execution, garnishment. Wages not subject to execution or garnishment. Well, another area in the Civil Code, the right to dismiss is subject to state regulation. All right. We will now formally take up the labor code, although we have already taken up substantially some areas of the labor code. By the way, what is labor code? Of course, when you talk of a labor code, this is a systematic codification of all laws on labor. And it is also defined as a charter of human rights and a bill of obligations for every working man. In other words, labor code is a law. It is a codification of all laws on labor. It is a systematic codification of all laws on labor. Ano malay nyo, ibigay ito sa bar. You should know at least the definition of labor code. All right. The Labor Code was actually signed into law May 1st, 1974 under a martial law regime. Under a martial law regime. In other words, it was actually signed into law by way of a presidential decree 442. And this draft of the Labor Code, as approved by President Marcos, was actually the work of then Minister Blas Ople, was then the Minister of Labor and Employment, who was instrumental in codifying laws on labor. And this was signed into law as PD 442 by President Marcos. So it took effect, but the Labor Code took effect in November 1st, 1974, 6 months after the signing. So there was a transition period of 6 months. What is the philosophy why the law provides for a transition or adjustment period of 6 months? Well, take note that this is a law that was drafted by a committee chaired by Minister Blas Ople. And since this was not deliberated upon expertly, perhaps, by an august body like Congress, then Minister Ople knew that there might be some problems later on that may arise, such as certain ambiguous provisions of the Labor Code. So they provided for a transitional adjustment period. That's the reason behind the law, why there was a transition of 6 months. By the way, the labor code composes 7 books: pre-employment, human resources development, conditions of employment, health, safety, dental, medical, compensation benefits, including ECC or Employees Compensation Commission, labor relations, loan dismissal, and Book 7, prescription and penalties. In other words, people, there are 7 books, but there are 3 main parts of the labor code: pre-employment, condition or state of employment, and post-employment. Well, you know what is pre-employment bago pumasok. State of employment or conditions of employment, nakapasok na. And of course, loan dismissal, which is post-employment, ay tinanggal. So hindi nyo makakalimutan yan. Bago pumasok, nakapasok na, tinanggal. Pre-employment, condition or state of employment, and post-employment. Bago pumasok, nakapasok na, tinanggal. O, alam niya yan, ha? Huwag niyong kalilimutan yan. Alright. So, what are the reforms introduced under the labor code? In one bar examination, salient features of the labor code. We have this principle of emancipation of labor relations. Number 2, transformation of workmen's compensation. Transformation of workmen's compensation. Number 3, placing of all government-owned and controlled corporations with regional charter, civil service law. Without the regional charter, labor law or labor code. Number 4, creation of an overseas employment body. Before, we have the National Seamen Board, the Overseas Employment Development Board, and the Bureau of Local Employment. But these bodies were already abolished and their functions taken over by the POEA that was established or created by virtue of Executive Order 797, restructuring the Department of Labor and Employment. Another, incorporation of Agrarian Reform. This is a misnomer. Imagine Agrarian Reform included in the Labor Code, Article 7. Another, updating of all laws on labor. Updating all laws on labor. So these are some of the features or the reforms introduced under the Labor Code of the Philippines. We have number 1, emancipation of labor relations. In other words, labor proceedings or proceedings before labor bodies exercising quasi-judicial functions are not governed strictly by rules of procedure and evidence. In other words, rules of procedure and evidence are relaxed in labor proceedings. In other words, the strict rules of procedure obtaining under the old order during the ages of the Court of Industrial Relations are now abandoned because they are wasteful procedures. Why? It does not it's not in accord, shall I say, with the doctrine of speedy labor justice. Imagine if a labor case is, if a labor complaint is filed under the old order, it takes time. A party may have died already, and still the labor case is still pending. That's why they have abandoned these strict rules of procedure and evidence and replace it with a body that is not governed by strict rules of procedure and evidence. And what is the legal anchor of these technical rules of procedure are not do not bind labor bodies? Article 227 under the renumbered labor code. Technical rules are not binding but resort to amicable settlement. So take note of this. Another is this transformation of Workmans Compensation. Under the old setup, if a worker is injured, he has to file a case against the employer. It takes time. He has to prove that he is not negligent. But under the new system, the liability is absorbed by the system. So there is now, under the new setup, you do not need to file a case against the employer because the liability is absorbed by the system. In the private sector, SSS, the ECC, etc. In the government sector, we have the GSIS, as the case may be, ECC. Take note of these people, very important. Another, placing of all government-owned and controlled corporations under civil service law with original charters, civil service law. Without original charters, labor code. Another is this creation of an overseas employment body. Well, we have the POA that monitors the deployment of overseas Filipino workers. And it is the POA that issues a license or authority, the Department of Labor and Employment. It's the POA. So, as to the recruitment and placement activities, this is within the domain of the Philippine Overseas Employment Administration. By the way, before we go into this, the POA is actually administered by an administrator, but under the old provision of the Labor Code, the POA can issue a warrant of arrest or a search warrant, but this was declared unconstitutional by the Supreme Court in Salazar versus Atsacoso, where the Supreme Court said that only regular courts can issue a warrant of arrest or a search warrant, as the case may be, except in the case of the Commission of Immigration or the Bureau of Immigration that can issue a warrant of arrest for purposes of deportation in the event that there is already a final order of deportation only for purposes of deportation. That's Salazar versus Atsacoso. No? So we have the POA. And take note that the POA is a body that monitors overseas employment, as I've told you a while ago. But take note that as to money claims, as to illegal dismissal, etc., and so on and so forth, the jurisdiction now lies with the labor arbiter or the regional arbitration branch of the NLRC under Section 10 of Republic Act 1842. In other words, Republic Act 1842 carves away some functions of the POA and now absorbed by the regional arbitration branch of the NLRC. However, there are still functions and powers that remain with the POA, like the disciplinary function. They can discipline overseas Filipino workers. They still have jurisdiction on pre-employment cases. Of course, when you talk of pre-employment cases, that these are actually cases before employment. Kaya nga tinawag na pre-employment. Like what? Matters involving collection of placement fees or placement fees, as the case may be. These are pre-employment cases. Another, as they have the function or responsibility, power to issue a closure order of recruitment and placement agencies, private employment agencies, or recruitment entities that violate the laws on recruitment and placement. And the last one, they can also conciliate or mediate on money claims or on matters that involve violation of employment contracts. But as to the legal issues, they cannot decide because it is the labor arbiter, pursuant to Section 10 of the Republic Act 1842. So take note of this, very important. Another, so since we are already with POA, let's discuss some areas here that are very pertinent in bar examination. Now, we have this principle of direct hiring. Take note that direct hiring is prohibited under the law. It's against public policy. Perhaps it is against public policy in order to protect our overseas Filipino workers from atrocious foreign employers or foreign principals. In other words, in order to protect our overseas Filipino workers from foreign principal who may inflict harm, injury to our Filipino workers physically or otherwise, especially on economic terms and conditions of employment. Secondly, why direct hiring is prohibited? In order to ensure that claims can be filed, in order to ensure that the workers can claim from their employer through their agent here in the Philippines, the Recruitment and Placement Agency, because the Recruitment and Placement Agency of the private employment agency here in the Philippines is now solidarily liable with the foreign principal. So if it would be direct hiring, do we have any jurisdiction over the parent foreign principal? Of course not. That's the reason why direct hiring is prohibited. Another, in order to ensure and protect the good image of the country abroad. Imagine if we do not monitor skillfully the deployment of overseas Filipino workers, kahit na yung mga magnanakaw, convicts, etc., and so on and so forth, who are escapees from jails or penal establishments, may land, may, shall we say, find their jobs abroad. And these are the very people who do some nefarious activities abroad. Many Filipinos were beheaded because of this. Why? These are the very rascals here in the Philippines who go abroad. That's the reason why direct hiring is prohibited. How could we protect the good image of the country if we do not have the, shall we say, an effective monitoring device in the Philippines? That is the reason why direct hiring is prohibited. Another, in order to ensure the remittance of certain amount of foreign earnings in the form of remittances, in order to be covered in order to be compulsorily covered by the mandatory foreign exchange remittance program of the government. In direct hiring, they are not, shall we say, covered. But if you are hired through a what we call a recruitment and placement agency or a primary deployment agency, you're covered under this mandatory foreign exchange remittance program. The government, where foreign earnings are exchanged in or sold into Philippine pesos through the Philippine banking system. In that way, we are able to, shall we say, bolster our economy through the influx of these foreign earnings that will make up our foreign reserves. That's the reason why direct hiring is prohibited. Of course, there are exceptions to this. Direct hiring can be conducted by members of the diplomatic corps, international organizations. We have also those who are granted special permits by the DOLE, Secretary of Labor and Employment. And in the case of name hiring or name hires, who are hired directly by public employment agencies like the POAA, name hires, those who are hired without the assistance of recruitment and placement agencies. So take note of this, very important. Recruitment and placement, you know the meaning of recruitment and placement under the labor code. It is not confined only to an act of canvassing, transporting, etc., and so on and so forth. Take note, even mere suggestion can qualify as an act of recruitment and placement. So never attempt to suggest, oh, that recruitment agency is the president is my friend. Be there. Don't worry. You just mentioned my name. Oh my God. There is recruitment and placement. Or a promise, with or without money, promise. That would qualify as an act of recruitment and placement. Another. Even if there is no payment made by the recruiter, this is an actual case, no payment, no receipt issued. The Supreme Court said, even if there is no receipt of money, that can be proven during the trial of the case. So, receipt is not an important element in recruitment and placement. Money is not an important element in recruitment and placement. So take note of this. Also, the number of people recruited is not important. That is not material. People versus Spanish says that even if there is only one person recruited, there can be recruitment and placement. And take note, the agency or the company or the recruiter is not only liable. Even their employees are equally liable if these employees know that really their company or their outfit is engaged in recruitment and placement. And this recruitment and placement agency engages in illegal recruitment and placement. They are equally liable under what we call the doctrine of imputed knowledge. Under the doctrine of imputed knowledge. So take note of these people, very important. Now, what are the types of illegal recruitment? This was given the faculty. Take note that there are those who say that there are only two types of recruitment: large scale and syndicated. Actually, there are four. Simple illegal recruitment committed by a licensee or holder of authority. Non-licensee, without a license, no holder of, not a holder of authority. Third, syndicated. Syndicated in the sense that this is committed by three or more persons who are in confederation or in conspiracy with one another. Take note, the important element here is confederation or conspiracy. And number four, large scale. Take note, large scale is otherwise known as qualified illegal recruitment. Large scale or qualified, said the Supreme Court. Committed against 3 or more persons, singly or as a group, shall I say. So these are the types of illegal recruitment. In the case of simple illegal recruitment, well, the prescriptive period is 5 years, you know this already. In the case of illegal recruitment constituting economic sabotage, like large-scale and syndicated, the prescriptive period is 20 years. Take note of this, very important. Now, by the way, actually, if you file a case of illegal recruitment, you can file a case of estafa under the revised penal code. So you can file both, one under malum prohibitum and one under malum inse. Malum inse, revised penal code. Malum prohibitum under Republic Act 1842, amending the labor code of the Philippines, otherwise known as the Overseas Migrant Workers and Overseas Filipino Act. No? Republic 1842. All right. Who can recruit and place workers abroad? You have to consider the citizenship requirement. Only Filipinos. Single proprietor, partnership, corporations. But in the case of corporations, the foreign equity is 25%, so 75% Filipinos. You have to consider also the capitalization requirement. It's gargantuan, malaki, no? Substantial capitalization. 2 million. Single proprietor, partnership, 2 million. But in the case of corporation, 2 million pesos paid up. 2 million pesos paid up. So take note of these people, very important. Also, in the case of this bond requirement, the posting of the bond, in order to ensure the payment of the claim of the workers. In the case of the surety company who issued or that issued the bond requirement of the Recruitment and Placement Agency, they may or may not be impleaded. Even if they are not impleaded, they are liable under the law. That was already settled by the Supreme Court, so take note of this. Now, well, in the case of the supreme penalty, what is the supreme penalty? Reclusion perpetua or life imprisonment. These are two different animals, people. Reclusion perpetua is not life imprisonment. Life imprisonment is not reclusion perpetua. So take note of these people, very, very important. Who cannot recruit? Those who have no license, no authority. Those whose license or authority has been cancelled, revoked, or suspended, and employs members of the Department of Labor and Employment, POA, and other agencies that are tasked to implement laws of recruitment and placement. Employees, officers of the Department of Foreign Affairs, they are now included under Republic Act 1842. Ano pa? In the case of travel agencies are not allowed to recruit and place workers abroad because it is publicly known that these travel agencies do the nefarious activities in facilitating the deployment of overseas Filipino workers through fake tourist or work visas. That's why travel agencies are not allowed. And of course, travel agencies are also in conspiracy, cahoots, with traveling with ticketing offices of airline companies. That's the reason why even ticketing offices of airline companies are not allowed to recruit and place workers abroad. So these are the very important things as far as overseas employment is concerned. Now, what are other features of the labor code? We have this Incorporation of Agrarian Reform, no. Another, we have this updating of all laws and labor. Okay. Article 3 is the declaration of policy. You know this. The declaration of policy under the Labor Code. The state shall afford protection to labor, promote full employment and equality employment, ensure equal opportunities, regardless of sex, race, or creed, and regulate the relations between workers and employers. The state shall assure the rights of workers to self-organization, collective bargaining, security of tenure, and just and humane conditions of work. Article 4 is about principle of construction. We are through with this. Article 5, it's very, of course, Article 5 is about implementing rules and regulations. So labor bodies are allowed under the law to, shall we say, draft their implementing rules and regulations. But this should be published to be valid. But what should be published are those implementing rules or regulations that are only legislative in character. Because if they are administrative in character, hindi na kailangan i-publish yan. And what are the requirements? Publication. And of course, another, you have to copy furnish the National Administrative Register, the UP Law Center. It shall be published in a newspaper of general circulation if it's not published in an official gazette. In official gazette, it takes time. That's why sometimes it's published in a newspaper of general circulation, unless the implementing rule itself provides for the effectivity date. But if the effectivity date is not provided, then the rule under the Civil Code shall apply 15 days. Now, you know this already. Now, Article 6 of the Labor Code is a bar area. It is a bar area. Listen very carefully. This is a bar area. All right. Take note that the grant of benefits under the Labor Code shall have its basis only if the juridical foundation exists. And what is this juridical foundation that exists in order for the employer, in order for an employee to be granted benefits under the Labor Code? And that is what? Employer-employee relations. All right. You may have some, shall we say, fixed minds on certain principles on employer-employee relationship. Perhaps what you know is this four-way test or the fourfold test in determining employer-employee relationship. The usual test, fourfold test, four-way test. But in one case, the Supreme Court said, indicia of determination. Take note, indicia of determination. So what are the tests? We have this selection or engagement of the putative employee. 2, the manner of payment of salaries or wages. Payment of wages or salaries. 3, the presence or absence of the power of dismissal. And the last one, the presence or absence of the power of control, not only as to the result, but as to the manner in effecting the result. In other words, these are the four-way tests, the fourfold test in determining employer-employee relationship. Question: does every form of control establish employer-employee relationship? According to the Supreme Court, take note of this. According to the Supreme Court, not every form of control establishes employer-employee relationship. A demarcation line shall be drawn between rules that only promote the result and rules that provide the manner or method that should be complied with by the employee. Under the first category, no employer-employee relationship. Under the second category, there exists employer-employee relationship. In other words, if there is lesser control, no employer-employee relationship. If there is more control, there exists employer-employee relationship. You cannot forget this. Control, control, control. Alam nyo itong control. You know this, control. So take note of this control. Lesser control, no employer-employee relationship. More control, you know, more control, there exists employer-employee relationship. That's why in the case of J. Sonsa versus ABS-CBN, since according to the Supreme Court, J. Sonsa, the ABS-CBN has lesser control over the manner or method that a job or work has to be accomplished by J. Sonsa, and ABS-CBN has lesser control. Therefore, J. Sonsa is not an employee of ABS-CBN, and he was treated only by the Supreme Court as a mere independent contractor. This was given the bar already. You know this. So take note of this control. Not every form of control establishes employer-employee relationship. Question: are there other types or tests, shall I say, tests in determining employer-employee relationship? One bar candidate said to me, "Sir, there's only this four-way test or four-fold test." Take note that in the case of Sevilla versus Court of Appeals, the Supreme Court had the occasion to say that there is another equally important test, and that is what? Economic reality test, or the economic relations test. According to the Supreme Court, the prevailing economic circumstances between the employer and the employee, such as inclusion of the name of the person in the payroll, submission of the name of this person with the SSS, with the pag-ibig, with the Bureau of Internal Revenue, etc. According to the Supreme Court, these are the prevailing economic circumstances, known as economic reality test or economic relations test in determining employer-employee relationship. In other words, no employer of sound mind will include the name of this person in his payroll if this person is not an employee of such company or employer. No employer will submit the name of this person with the SSS, with the pag-ibig, with PhilHealth, if this person is not its own employee, said the Supreme Court. So these are the prevailing economic circumstances that may determine employer-employee relationship. This is the Sevilla doctrine, but this was bolstered by subsequent doctrines people. So take note of this, very important. And who can hire an employee? It's the employer or his duly authorized agent. So, what is this principle of competent hiring in labor law? The principle of competent hiring simply means that, first, an agent has an actual authority. Two, the agent has an apparent authority. Three, the agent has no authority at all, but his act was ratified by the employer. These are the principles of competent hiring by an agency or by an agent of the employer. So take note of these very important people. Of course, in other words, it is the distinct existence of employer-employee relationship that is important in the grant of benefits under the Labor Code of the Philippines. All right, question, another question. Which is the usual bar area? I gave this in the bar in 2008, so you should remember this. This is a favorite area of bar examiners. Okay? What is that? This case where, although there is no contract of employment, the law mandates the existence of employer-employee relationship. And what is that provision of the Labor Code where no contract of employment, but the law mandates the existence of employer-employee relationship? That is the case of labor-only contracting. Take note, people, that labor-only contracting is against the law. It's against public policy. Thus, the employer, the indirect employer, the statutory employer, principal employer, principal owner of the project, pare-pareho yan. They are the same. The employer is treated as a mere agent or intermediary of the principal. The contractor, shall I say. The contractor, the labor-only contractor is treated as a mere agent or intermediary of the employer, indirect employer, statutory employer, principal owner of the project, pare-pareho yan. In other words, as between the employer and the labor-only contractor's employees, as a rule, there is no employer-employer relationship, but the law intervenes by way of creating a relationship between the two, employer-employer relationship. Why? Labor-only contracting is against the law. That's why, as a penalty, there is no existence of employer-employer relationship between the contractor's employees and the principal or employer or owner of the project. Take note of this. Very important. So, under the Labor Code, this is one instance where there is no employer-employer relationship. The law sets in. There exists employer-employer relationship. Another instance where the Labor Code and its implementing rule regulation provide that there is no employer-employer relationship. That is in the case of working scholars. In the case of working scholars, there is no employer-employer relationship between the school and the working scholar, but there is a requirement. What is that requirement? The requirement is that the working scholar should be given the real opportunity to choose or finish a chosen career or course. Take note of that. Real opportunity to choose, finish a chosen career or course. In other words, people, if the working scholar is not given the real opportunity, he is not a working scholar. Therefore, he is treated as an employee of the school. And there exists employer-employee relationship. But if the worker or employee is given the real opportunity to choose or finish a chosen career course, he will be treated as a working scholar. Now, give me an example. For example, here is a driver. He's a graduate of a bachelor's degree. He wanted to become a lawyer, so he approaches a dean of the College of Law. Dean. Oh, why? Ano bang gusto mo? Sabi nung dean. I would like to become a lawyer, but we belong to a poor family. All right. What's your wish? I wanted to enroll in the College of Law. I will provide my services for free, but the school should provide me the opportunity to become a lawyer. Okay, said the dean. All right, you can enroll now. For the dean who has no driver, the dean wanted him to the dean wanted to detain him further, perhaps about 10 to 15 years as a driver of the College of Law. So the dean enrolls this driver with the law school. First semester, 1 unit. Second semester, 2 units. Third semester, 3 units. Fourth semester, 4 units. Is there real opportunity here? There is no real opportunity. Therefore, since there is no real opportunity, he is treated as an employee of the school. However, he is given, provided, allowed to enroll 15 units every semester. That's real opportunity. He is treated as a working scholar. Okay, assuming he is a working scholar. So while driving, because this driver is some sort of a maniakis. He saw a lady while driving. So he has to put a stop on the brake. But instead of placing his foot on the brake, he placed his foot in the accelerator. So a pedestrian, the beautiful lady pedestrian, was, shall we say, run over by this driver, causing injury or death. So a case was filed against the driver and the school. The school said, we are not liable because the driver is a working scholar, no employer-employee relationship. Is there employer-employee relationship? No employer-employee relationship because he's a working scholar. But according to the Supreme Court, for purposes of civil damages, quasi delicto, for purposes of civil damages, the working scholar driver is treated as an employee, and the school is treated as an